We've got a couple of trials coming up, and Erik is our lead attorney. You want to talk a little bit about trial preparation?
Sure. The first thing we do in trial prep is basically come up with a theme, a story of what happened that tells basically the facts of the case in the light most favorable to us. The theme may relate to the defendant's conduct. The theme may relate to the plaintiff and the kind of person the plaintiff is, the kind of conduct the plaintiff engaged in. But we start with a theme and we try to build all of our evidence around that theme. We also spend a great deal of time preparing our clients for their testimony in trials. There's nothing more frightening, I think, to the average layperson, somebody not experienced either in public speaking or the practice of law, than actually having to get up in front of a lot of people and speaking, even when you're just telling your side of the story. And we spend a lot of time working with our clients on doing exactly that, explaining to them what they're going to face from the other side. One of the most important things we do is to educate the client as to the importance of remaining calm in the face of rigorous cross-examination from the defense lawyers. The insurance company lawyers, the ones working for them, will try to cast our clients in a very unfavorable light. They suggest that our clients are exaggerating their injuries, that our clients are exaggerating the way the accident happened, the amount of impact that occurred in a car wreck case, for instance. But no matter what the nature of the case, they try to claim that our clients are exaggerating or twisting the facts, and they go after our clients, attack our clients. And the natural human response to that is to attack back, to defend yourself. But when you're doing that, you lose credibility. Lawyers are the most hated people by the average person that exist in the world. And so if a lawyer is attacking our client and our client is taking it and accepting it and remaining calm and showing their true colors and their character, the lawyer looks awful and the juries will punish the defendant. That's just one of the ways we go about preparing our clients for trial.
You know, one of the things that you reminded me of that differentiates ourselves from other law firms, and you haven't touched on it yet, is in our brand new San Antonio office, you know, we're going to be able to do different types of setups because of our mock trial, our mock courtroom, right?
Right. That was the next thing we were going to talk about is we've had a lot of demand for our services throughout the state, and we're making a big expansion. We just are moving into an 11,000 square foot office. It's our largest office to date. And because of all the space that it has, there's a very large room we're setting up as a mock courtroom. So Erik was talking about the importance of trial preparation for our clients, for our Austin folks who are willing to make the drive, or for our San Antonio clients. We're going to have a mock courtroom set up with a judge's bench and a jury box and tables for the plaintiff and defendant, and a full electronic setup to put evidence on, a glass board to write on. And for our trial prep, we'll be able to bring the clients in and actually, here's what it's like to go sit up on the stand, and we'll have a judge there, and we'll have, probably the easiest way to refer to it is good cop, bad cop. So we'll have two of our lawyers alternate between plaintiff and defendant, and they'll get to see what it's like to get grilled about something. And we have the whole setup videoed so they can sit and watch. And, you know, Erik was talking about your natural urge to fight back and to attack. And I think our clients, if they get combative, that it really does make them look bad. And the easiest, well, not the easiest, but the best thing to do is to just sit there and be polite and let the lawyer look like a jerk. Defense lawyers especially, they're really good at looking like jerks and attacking people. And, have you ever seen that backfire, Erik?
Oh, many times. I've seen both things that you've talked about. I've seen lawyers who were so scripted and had everything prepared so far in advance that the jurors didn't trust it. They thought that the lawyers had canned the witnesses' testimony to the point that they weren't sure whether or not it was the lawyer testifying or the witness. And we avoid that. We don't tell our clients what to say. We will work with the client so they know how to present themselves, but the actual testimony will be spontaneous and it will be the client's own testimony. But yes, I've seen lawyers who have gone after the client, and what happens is if the client isn't combative, if the client remains calm and staid throughout the presentation, it makes the lawyer angry because he's counting on the person he's cross-examining to fight with him. And so the lawyer gets more and more combative, trying to generate exactly the kind of fight he wants. And the more he gets, the more combative the lawyer gets and the calmer the client gets, the more horrible the lawyer gets. And the jurors will punish that. They'll punish it with a verdict. They'll punish it with the amount of damages they award. Damages are not always what the court instructs the jury they should be, compensation for injury. Sometimes they're compensation for how mad the jury gets at the wrongdoer in the particular case.